All right, welcome back to the Region Law Podcast, another episode of Constitutional Conversations where we're trying to make constitutional law more approachable. On it, we have another fantastic episode with our 3L Regent Law School student, star student, Greta Griswold. Man, tongue tire.
We're tongue tied with the superstars, Pat. That's when the superstars are here, we're tongue tied.
Okay, so we just had an episode about how we interpret the Constitution, and there's different ways to do that. We have an episode kind of connected to that within interpretation principles or how we do that. Today's episode, we're going to talk about legal precedent. What is legal precedent? What is legal precedent? And what in the world, later in the episode, is stare decisis? So legal precedent is a word maybe people have heard before. Greta, I'm going to hand it straight over to you as a law student here. Describe to us what legal precedent is and how it might play into how a case is decided or how a judge could decide a case.
So in its most basic form, legal precedent is basically how have we decided something like this before? How have we interpreted this before?
In a previous case.
And then what we're likely going to do is do that again to be consistent. You said this accidentally, but I think it's actually appropriate. So maybe then a legal deprecedent would be when we ignore the things that we've done.
That's good. I might be stealing that, Pat.
When we ignore what we've done in the past. And that will come around more with stare decisis as well. And that's a Latin term that Professor Edmonds is going to get into. And it's totally fine if you've never heard that before. My sister came and sat in a con law class. She, no legal background, no nothing, decided to start taking notes. Heard the word stare decisis and wrote star in my eye sis. Like a star in your eyeball. She knew it wasn't right, but that's what it sounded like in her head. But that concept mainly means we should do what we've done in the past. So legal precedent.
Let me ask you this quick question. Why? If we think judges are wise, I mean, judges are in the Bible. Judges in courts, we think they're wise. They're particularly there because they're people with wisdom and character. Why shouldn't they just be deciding from scratch the court before them? I'm sure there's a number of reasons why legal precedent is a good way to go.
I think one of the biggest reasons is you want predictability in court decisions. So you don't want a judge in Oklahoma, where you're from, on a constitutional law issue, making a totally different decision from a judge in North Carolina, where I'm from. And then people who are bringing lawsuits don't know what to expect. Their lawyers don't know what to expect if there's no submission or following legal precedent. And then that also that predictability also can contribute to fairness, because it would be unfair for one person bringing a lawsuit in one area to get it applied in a different way than somebody in another state when it's an issue that has been determined by, say, the Supreme Court. And so because the Supreme Court is the highest court, it is binding on all courts. So specifically within those issues, it creates a lot of instability if we don't follow legal precedent. But
legal precedent could have different levels of authority. I mean, a little court in a rural community in Alabama is not setting legal precedent for higher courts in another state or a federal case. But it's this idea, wouldn't efficiency also be another decent reason that a good court has already spent a lot of time weighing all the factors. So when the same set of factors in this case has already happened and a good court has already decided, we already know the outcome. We don't have to waste more public money on figuring this out. in this circumstances, you're guilty. In this circumstances, this side wins.
And I'll just interject because I think the another question that does this is the fundamental question with the Supreme Court, right? The Supreme Court is the final arbiter of all what the Constitution means. Why should one court in 2025 be bound what a court in 1942 said? I mean, I think that is the question. And I will invoke the dissent in Dobbs, surprisingly, which says
what is Dobbs? What is Dobbs?
Is the big case that came down a few years ago that overturned Roe v. Wade to the states to determine abortion. And the dissent there was because Roe v. Wade was overturned, they invoked stare decisis and said we should adhere to precedent, past cases, Roe. And one of their principal arguments was, and I think there is merit to what they're saying, when you're dealing with fundamental rights, right to an abortion, all these types of things, people structure their lives around these rights. People have an expectation that they will have the ability to speak freely, to, under Roe, get an abortion, to do these things. They structure their lives under them. And when the court comes and uproots those things that have been around for a long time, have become settled, that disrupts the way of life for a lot of Americans. You can agree with that or not. You can think that's a little hyperbolic or not. We can talk about that another time, but that is one of the principal arguments for at least stare decisis in the Supreme Court.
Did we already define stare decisis, Greta?
Did.
Yes. I mean, Professor Edmonds could give what it actually means in Latin that I don't have on the top of my head, but basically the concept that we should follow legal precedent. So whatever it is, we should do that.
Unless we, for some reason...
Unless there are reasons, which I think we're going to get into, and people feel differently about these reasons.
I'm just going to put out there, Pat, trigger alert. We're going to be talking about abortion in just a second, and physician-assisted suicide, and all these really, and same-sex marriage. So we're just going to dive right in. Whatever.
Okay, so legal precedent.
Yeah.
Essentially, in the American court system, if a court has already decided in a case, a matter, if it's applicable to a case, same set of facts, and the court before you has authority over you, then you pretty much know how your case is gonna fare, because that legal precedent, unless for some reason we're gonna default from that, we know how this case. And talk about predictable. So if I'm considering bringing a lawsuit, if my set of facts are the exact same as someone in my jurisdiction, if I'm on the losing side, it'd be pretty dumb to file the lawsuit, because I know kind of how it's probably gonna. And I mean, that's actually pretty good for society.
Yeah, exactly.
Okay, so that's legal precedent. Stare decisis is if someone hears that on the news, it's a fancy Latin word referring to the use of precedent.
Yep.
Professor Edmonds, take us into some cases talking about this.
All right. Everyone buckle up. Put on your constitutional seatbelt. So I thought it'd be fun to talk about what I mentioned earlier, the Dobbs case, and the saga associated with Dobbs and Obergefell and everything that happened there. So let me just backtrack. We talked about this in a prior episode. There is this thing called substantive due process. It is a doctrine that is housed in the 14th Amendment. There's a due process clause in the 14th Amendment that says you cannot be deprived of life, liberty, or property without due process of law. The Supreme Court, for a while now, has said that there is substantive meaning from the word liberty. And from the word liberty, we can understand that there are certain fundamental rights that Americans have. And this is kind of what I was saying earlier about the Dobbs dissent. They're saying people think they have a right to an abortion. They have a right to privacy. They have a right to same-sex marriage. These are all housed under the word liberty. And so for a long time, we interpreted liberty very broadly.
Okay.
And we kind of raised the level of abstraction. Right? Well, we think there's a right to privacy. Well, if we look at that broadly, more generally, what falls under the right to privacy? And we look at marriage generally, what falls under the right to marry generally? And ultimately, what the conclusion of this type of interpretation came to was with Obergefell. So Obergefell was a case in 2015 that constitutionalized, said there is a fundamental right to same-sex marriage. And one of the things I want to focus on is not really why they got there, how they got there. That would be kind of interesting for our last episode, but it's really precedent-based. So, Pat, we've talked a lot about in our previous episodes that you can watch the news and you're going to look at, shorts on YouTube or whatever, and you're going to get a soundbite of what happens. I promise you, when you saw the decision of Dobbs on the news cycle, there was no idea that it was following past case law. All you heard was overturning Roe v. Wade, throwing out precedent. That is true and not true at the same time. So let's just break that down. There was a case in the late 90s called Glucksberg. And Glucksberg was a case that said, what was determining, is there a fundamental right to physician-assisted suicide? The Supreme Court at the time revamped the way they should determine fundamental rights. Because, right, we're just reading the word liberty. What does that mean? Well,
literally, that's the word in the original Constitution. That's all for a textualist. That's all you got.
That's all you have. And you can't, no mode of textualism can import all of the meanings the court has given. And so ultimately, we kind of just reconciled the court's going to determine what are fundamental rights. And that's what we're going to do. And in Glucksberg, the court ultimately said, we're going to rein this in a little bit. In order to determine if something's a fundamental right, one of the things we need to do is determine if it's deeply rooted in history and tradition. Well, history and tradition. We've heard this before on the podcast. This is where it really originated, was in Glucksberg. And so it said, going forward, if we're going to determine a fundamental right, we're going to see if it's deeply rooted in our nation's history and tradition. Well, fast forward 20-ish years to Obergefell, and the majority opinion was faced with, well, how do we determine same-sex marriage as a fundamental right under Glucksberg? It's not controversial to say, at the time of writing of the 14th Amendment, no one was thinking about same-sex marriage. They were not. That's not controversial. So how did the court in Obergefell work around Glucksberg? Well, quite honestly, they just kind of disregarded it.
Okay.
The court there, which was Justice Kennedy, said, well, we care what history and tradition says, but actually, we also should care what the modern, culture thinks and how society has progressed. And society has progressed that we should accept same-sex marriage as a fundamental right. That's what we're going to do. And that's ultimately what happened.
So they just didn't follow stare decisis or legal precedent.
They did not follow the means of interpretation that they had established as the rules of the game going forward. That's ultimately what happened. That frustrated a lot of people. A lot of people thought it was great. And then just about 10 years later, you get to Dobbs. And the Supreme Court has on the chopping block abortion, right? A lot of people do not think abortion is something that should be protected under the Constitution federally. It should be something that states determine. And so the Supreme Court there, and this is why it is true that they overturned case law, and it is also true that they followed case law. Because what did the court say in Dobbs? They said, we're going to apply the test we made in Glucksberg. Is this potential right deeply rooted in history and tradition, in American history and tradition? Abortion is not. Abortion was banned for a long time, and they gave a ton of reasoning of why this is not deeply rooted in history and tradition. Thus, because it's not deeply rooted, and there's no historical basis for it, we are not going to protect it anymore as a fundamental right. So Dobbs is a polarizing case. And as I said, everyone's going to say that they're overturning precedent, that they're not adhering to stare decisis. But quite honestly, Obergefell didn't either. The rules of the game were made in Glucksberg, and Obergefell chose to disregard those, and then Dobbs chose to disregard Roe, and it's ultimately what we have determined is that the rules of the game now, with determining fundamental rights, is this right deeply rooted in history and tradition? That is what Dobbs said are the rules of the game now, and that's what we don't know, but that's what we think we're going to adhere to going forward.
That's really interesting. So depending on how you're viewing Dobbs, one person may say it's totally abandoning precedent, the precedent of Roe.
Right.
And another person would say you're actually getting more in line with a strong precedent case in Glucksberg.
It's interesting because some would say that Dobbs is judicial activism, rogue judges, just doing what they want. And then some would say that Obergefell was that. Ultimately, what did begin the trend of interpreting fundamental rights was Glucksberg. And it said we look to history to determine if this is a deeply rooted tradition that should be protected as a fundamental right. And that is what Dobbs did. So again, it's interesting how when you just rely on the media to understand these cases, you're going to get a view that media outlet likes, whether it be from from a Fox News side or an MSNBC side. It's going to be skewed, right? I'm not trying to pick one side or the other, but precedent really did play an important role in the overturning of Roe v. Wade, but in two different ways.
So I'd love to go ahead, Greg.
To add to that is you can also look at the court, as Professor Edmonds has said, and different people are going to feel differently about what happened, and some of them are going to support their argument the same way. And so I think another thing that's particularly interesting about Dobbs is they had an opportunity to overturn a lot of things based on the Glucksberg test about what's deeply rooted in history and tradition, because what the other position is upset about is there's a whole line of cases that are expanding what liberty means. And Dobbs went to lengths to say, well, we're not overturning this one and this one and this one and this one and this one in this line of cases. We're just overturning specifically the abortion issue in Roe versus Wade. So I think that also is how this kind of uniquely ties back to what we were talking about in another episode with interpretation then about, okay, we're looking at what liberty meant and we're deciding it only in this specific case, even though this could have ramifications for this whole line of cases that led to Obergefell.
Yeah, ultimately, not to dive in too much, but if anyone's aware of the Spider-Man meme, where the two Spider-Mans are pointing at each other, that's essentially Dobbs. Both sides, the dissent and the majority, are pointing at each other and saying, you are the rogue justice. You are the one disregarding the past. They both have their arguments for why they're right.
This may be an unfair question, or maybe I don't even understand the argument, but if I just ask the simple question of, so does the court care about precedent or not? If a person is listening to this and goes, well, or do they just act like they do and make the decision they want? What would be?
The cynical side of me says they don't care. Now, the reason of the majority in Dobbs is that, and they cite cases for this, that we do adhere to precedent and to stare decisis. However, when we are dealing with constitutional issues that affect individual rights, issues that affect the structure of our government, we don't just go along to get along. We want to do it right. Now, the opposite side says, well, that's only what you think is right. I think this is right. So it's a mess. Okay? It's a mess. And I'm not going to lie, I agree with the majority in Dobbs, so I'm happy with it. I know a lot of people that don't agree with it. And it's a polarizing issue, but ultimately precedent is one of the linchpin issues in that line of cases.
All right, this is probably a good place to stop. Legal precedent, or if you hear it, stare decisis, it's not an item on an Italian menu. It's a Latin term basically saying, let's start with precedent. Thanks again, y'all. I learned a bunch on this episode.
Thank you to Greta for being a guest on the show. She's been awesome.
Yes, she's been an incredible contributor to Constitutional Conversations. If you're a prospective law student, You might be thinking, I could come to Regent Law School and be the next contributor. I mean, look at Greta. She already knows twice as much about the Constitution as me. So, hey, come to Regent Law, learn more about us, the Con Law Center. We hope you follow these episodes, and we hope you're learning something from them. All right. We look forward to seeing you next time. Thanks a lot.
Like and subscribe. Have a good one.